Bonsoir, good evening everyone. My name is Mark Robbins, Director here at IPAC, and I'm going to be your host tonight as we dive into the subject of emergency legislation. For the first time in decades, Canada saw the widespread invocation of emergency legislation in response to the COVID-19 pandemic, as one government after another raced to invoke their emergency powers. Up until recently, most people's experience with a state of emergency would likely have come from the movies, which of course are not going to do justice to such a nuanced issue. At a high level, we all understand that declaring a state of emergency signifies that there is an emergency that governments need to respond to. But beyond that, most of us are likely to be fuzzy on the details. In today's times, however, these details are increasingly important, especially with the prospects of a state of emergency being in place for many more months, if not even years. The Institute of Public Administration Canada's National Capital Chapter is hosting this talk tonight in order to bring more clarity to the issue of emergency legislation for public servants, of course, who are now finding this issue to be an important part of their daily work, but also for intellectuals interacting with this issue at a more abstract level, as well as the interested public at large who want to be more informed. We are very happy to have all of you from all stripes joining us tonight. We've assembled two very fantastic speakers for you. First, I'll introduce Carissa Matheson, who is a professor of law at the University of Ottawa, a leading constitutional scholar. She's the author of two recent books, Courts Without Cases, The Law and Politics of Advisory Opinions, and also The 10th Justice, Marc Nadon, Judicial Appointments, the Supreme Court Act Reference. Professor Matheson has published numerous articles in constitutional law, as well as in criminal law, legal theory, and law and technology. Many of you will also be interested to know that she has a chapter forthcoming on the subject of emergency powers in the volume entitled Vulnerable, the Law, Policy, and Ethics of COVID-19. Our second speaker is Dr. Kathy Brock, who is a professor at the School of Policy Studies at Queen's University. Dr. Brock is a widely published and respected scholar on issues of Canadian governments and politics, public administration, federalism, and constitutional matters, on which she has served as a nonpartisan advisor to the federal government and parties, provincial and territorial governments, and First Nations. She's the current past president of the Canadian Association of Programs in Public Administration, or CAPA, who I'll also just mention has a really great conference that they host each year. And she's also a past National Research Chair for IPAC, us. With that said, I'll get us started with a fairly easy question to bring us into the talk. What exactly are emergency powers and what is their purpose? Furthermore, how do emergency powers relate to the Emergencies Act? Carissa, maybe you could start us off.
Sure, thanks very much. And thank you for the invitation. It's a real delight to be here, and thank you to everyone for joining on this sweltering day in Ottawa. I want to just apologize in advance if I appear to be looking down. It's my dog who is demanding some attention, and I decided against having him claw at the door, which would probably be audible, so that's what's going on there. So emergency powers are temporary allocations of extraordinary authority to state actors to deal with crises that threaten all or part of a society in a profound way. Classically, they would have been used to respond to events like war, famine, severe economic upheaval. In the modern context, they may be thought of as available to deal with different kinds of events that pose a threat to a highly integrated and interdependent society. So the Emergencies Act, the Federal Emergencies Act, sets out 4 categories of emergencies to which powers are then arrayed in increasing order of import. So the 4 emergencies are sort of laid out in what is conceptualized as an increasing scale of risk. So the first is public welfare emergencies, which is in fact what is most likely applicable to what we are currently experiencing. So a pandemic would be included among those. Then public order emergencies, international emergencies, and finally war emergencies. So the Act delegates different powers or provides for different powers to respond to these different categories of emergency. And it all happens under the oversight and control of Parliament, which is a very important feature, but the Emergencies Act does permit, or does state that Parliament can essentially delegate to executive actors very significant decisions and powers. The Act also acknowledges, in an important way, Canadian federalism by preserving the concurrent authority of provinces to deal with emergencies that arise under their areas of jurisdiction. It also specifies that its powers are triggered when existing federal law is insufficient to the task. So that's really part of the framework by which we can understand something to be an emergency within the context of the Emergencies Act. One point I want to make that is sometimes missed in terms of the very natural focus on the Emergencies Act is that for the federal order of government, the Emergencies Act does not exhaust the concept of emergency powers available to Parliament. And in particular, there always remains open to Parliament the ability to respond to a variety of circumstances with legislation that would be considered valid under the emergency branch of the peace, order, and good government power, which has been used many times since Confederation, largely to correspond to wartime, but there have been a few other select instances. So the emergency power, the emergency branch of the division of powers permits Parliament to arrogate to itself powers that clearly fall within provincial jurisdiction. So it's quite a significant and profound reserve power, if you will, that's left to Parliament. But and there are a number of safeguards that are built into how the courts have interpreted that. I also want to point out that nothing in either the Emergencies Act or indeed the Emergency Powers Branch supersedes other constitutional protections and norms. So for example, the Charter of Rights is not suspended during an emergency. The Emergencies Act itself states that it is cognizant of the state's duty to respect the Charter. That being said, it is largely accepted that were a case involving a challenge to the exercise of emergency powers to go to the courts, they have in the past, and it's expected today, they've tended to defer, at least while the particular emergency is ongoing, to the judgment of Parliament with respect to the fact that an emergency exists, and they've been more deferential to what is required in the judgment of Parliament to respond. But that really hasn't been tested in the modern context, and there may well be some really interesting litigation that we can expect arising from the COVID era.
Kathy, your thoughts?
I think we've covered most of the questions here, but I guess one thing I would add just on the first question, when you ask about the emergency powers versus the Emergencies Act, is you do have to distinguish between some regular legislation that the federal government has access to and the Emergencies Act itself. So for example, in the Quarantine Act, there are emergency provisions and emergency powers that are specific and the government's relied on in this situation. Also, if you look at something like the Emergencies Act across Canada and how it interacts with police acts, it doesn't affect the police. But the police would be subject to the usual provisions that apply under our Constitution, which would be, they have to be reasonable in how they would choose to exercise their discretion in emergency times. So for example, if there's a gathering, the police aren't going to go in a really heavy-handed way. Instead, they're going to ask people to leave or ask them to social distance, and they're going to be a little more deferential because there's been some question about why the police have not dispersed some of the larger gatherings at beaches, and that would be why. So you do have regular emergency powers, and then you have the Emergencies Act, which, as Charisma has said, is for exceptional times.
As a non-expert, I'm kind of struck in that it seems to me to have more powers than I would have expected in some areas and less in others, to be a bit more restrained. What distinctive characteristics would you say there are to emergency legislation in Canada? And similarly, how does the Emergencies Act differ or relate to the War Measures Act, something that many of us would have heard of from grade school?
Well, the Federal Emergencies Act is different than the provincial acts. So each jurisdiction has its own emergency legislation, and they can differ fairly substantially. So, for example, the federal government and the Ontario government would say that if the cabinet is going to recommend suspending or changing a statute, that it should be reviewed by Parliament or by the Ontario legislature, as the case may be. But the BC legislation doesn't have that provision in it, and that's the one that the BC ombudsperson just caught the government on and said, you've overextended your reach because you've actually suspended a statute without the authority of the legislature. So each act has different peculiarities to it, but if we're looking at the federal emergencies legislation, it's very interesting because it says that the Emergencies Act gives power to cabinet and makes cabinet responsible. So that's very important. We have a clear locus of responsibility, which is consistent with the Westminster model of parliamentary government. But then it says it's subject to parliamentary supervision. This was a clear departure from the War Measures Act. In 1970, when the War Measures Act was used, or in World War II, World War I, basically, cabinet had carte blanche to do what it thought was necessary to deal with the emergency. And it actually located right with the Prime Minister, and at that time it was himself in those cases. So it meant that there was a tremendous grant of power, and they could bypass the Senate and the House of Commons in what they wanted to do. This legislation says no, that's not on. It's a key difference. It says it's going to be subject to parliamentary supervision. And what's really interesting about parliamentary supervision is Parliament can review the declaration of emergency, and the cabinet must provide reasons for the declaration and a brief sketch of what they think the state of affairs is. And Parliament can revoke a declaration of emergency. So that's a real check on cabinet in actually using this legislation. But also under the emergencies legislation, the Parliament can look at every order and regulation passed by cabinet. And that's a tremendous power of review. It's very important. It's something that we don't have in operation right now because the Emergencies Act has not been declared or invoked. And to me, that's a bit of a problem with the current situation. They can also look at the actions of government, and the Emergencies Act requires an inquiry that's called almost right after the emergency has ceased and reports within a year. And Parliament is going to have an opportunity to scrutinize and say, here's what we did well, here's what we didn't do so well. The War Measures Act didn't have those types of provisions. It was an act that could be declared if there was war, insurrection, or unrest that the federal government felt constituted an emergency. And the cabinet was the one who determined what that was. So even though the courts might be deferential in the case of the emergency legislation now, and that's the prediction of most lawyers who have been writing on this, with the War Measures Act, you didn't really have that judicial scrutiny to the same extent that's possible because it's written into the act. But even more so, Parliament is the first level of scrutiny, and it's going to be the more powerful one. So that's key.
Yeah, I would, the only things I would add to that are it's interesting to compare the War Measures Act with the Emergencies Act, because in some ways it's more restrictive in terms of the types of events for which it was designed, war, insurrection, or invasion. Whereas if you look at the Emergencies Act, there's this sliding scale, and it clearly contemplates being applied to more situations. But as Kathy has said, once that determination is made, the power is plenary to the executive branch, whereas in the Emergencies Act, it's very much structured, and it contemplates certain actions corresponding to certain emergencies, but not others. The other point I would make about the Emergencies Act is the role for provinces. So there's a duty of consultation where acts are being contemplated that will affect provinces and provincial powers. And importantly, if an emergency is confined to a single province, the act cannot be triggered absent a request from the governor and council of that province, which is a very clear departure. There was criticism at the time that the Emergencies Act was enacted, that it could possibly enable greater intrusions on civil liberties. The worries were really focused around the second category of public order emergency, which is crafted in a fairly broad way. We haven't seen that because we haven't had it invoked. And if anything, today we've seen some criticism that the Emergencies Act is not fit for purpose because it hasn't been invoked. I don't tend to share that view, but it's interesting to see the very different direction that the criticism has been coming from.
That actually leads quite well to my next question. Many of us will recall when the pandemic started to gain momentum that provincial and municipal governments, all provincial governments in fact in Canada, and municipal governments representing most major Canadian cities, ended up declaring a state of emergency and put their emergency legislation into force. But to date, the federal government has not done this. Why is that? And to relate to something that Kathy had mentioned earlier, is part of the answer to be found in the fact that the Quarantine Act was invoked? Is that perhaps part of a response to COVID, which made the Emergencies Act unnecessary?
Yeah, well, a few things here. The Quarantine Act was key. One of the key conditions for invoking the Emergencies Act is that there cannot be any other piece of legislation that would deal with that situation. So in the case of COVID, we've seen the Quarantine Act invoked, we've seen the Defense Act, we've seen the Labor Act, the Security and Intelligence Act invoked, the Emergency Management Act. So the federal government has a wide array of legislation at its disposal. And then, as Charisma said, in order to invoke it, the federal government needs the consent of a province. So a province would have to request it. And it would have to be a situation that was clearly beyond the capacity of a province to deal with that situation. So when we look back to March, it was the last week in March, when the Prime Minister met with the premiers, they discussed this. And the premiers were very divided on whether or not there was provincial incapacity to deal with this situation. They said, we think we've got to hit, or we can address it through collective action. So at that point, the federal government quite appropriately said, and the Prime Minister said, this is a measure of last resort. We don't want to invoke it unless we have to. And it would be in the case of a public welfare emergency, which can address human disease, that they would most likely have invoked it. Now, what's interesting is if you look at the fiscal update that was released today, it provides two scenarios. And one of the scenarios is actually quite daunting if you read into it, you know, what they're saying. And in that case, then it could become the case where the federal emergencies legislation is necessary to deal with the situation if we go into an economic freefall, or if they do see a wave of cases that is much greater than in the first instance and begins to overwhelm our health facilities. The federal government could then step in and help out with facilities. It could help out with providing payments to the provinces, etc. So that would be a case where it comes into play. But the federal government is not going to do that, and it cannot do that unless the provinces, at least one of the provinces, requests it. But they would do it given the nature of collaborative federalism with more than one province, most likely, before they acted that strongly. And provinces are going to be very nervous to see the federal government come in, because the federal government has sweeping powers and its legislation trumps provincial legislation in most cases. So the feds have to tread carefully. Traditionally, when we've looked at how the Peace, Order, and Good Government Clause has been adjudicated in the past, they've always said it really cannot wipe out provincial jurisdiction. And there's a danger with the Emergencies Act, is that it could wipe out areas of provincial jurisdiction, even temporarily, but that's still significant.
I would just add to that, and this is really drawing on my chapter, which is forthcoming in a book that you mentioned that's been co-edited by Colleen Flood and Jane Philpott and a number of other really amazing scholars and experts. That one thing I've noticed in terms of the demands for federal intervention is that they actually tend to involve actions that wouldn't squarely fall under the Emergencies Act. So for example, the tragedy of long-term care homes, and why doesn't the federal government do something? Well, that would actually require special legislation, quite apart from the Canada Health Act, to take over labor relations and a whole host of operational matters with respect to long-term care homes that is clearly within provincial jurisdiction, that could only be done on in a temporary manner unless you actually amended the Constitution. I think also of other contractual arrangements like rent control, which do have a precedent in Canada under the War Measures Act, but and which could conceivably be contemplated, but again are not really cognizable under the specific powers under the Emergency Act. There's even been discussion about whether something like a national testing regime easily corresponds to the powers under the public welfare emergency. So there's an aspect where what is being requested doesn't squarely meet the powers that the Emergencies Act has contemplated. Second thing I would say is that and this is an argument I make in the book, in my chapter, is that because of the division of powers over 150 years, the two orders of government have developed complementary and distinct areas of expertise that it's very difficult to ramp up in a field that you are not familiar with in an emergency. So this is why, the federal government, I think properly, has been looking to the provinces to use their long-held expertise in healthcare and indeed lower orders of government than the provincial level, to respond to the particular needs in various regions. And that's not to say that the federal government shouldn't provide support, which it has, but to actually take it over, which is what would be contemplated at least in some of the debate that I've seen. I'm actually not sure that would be productive. I think an emergency is actually the worst time in which to expect one order of government to develop the kind of expertise that in an area that it's rarely in which it's rarely exercised in.
I've just gotten a quick note that we have a good deal of interest for questions, so I'm going to speed through the next couple ones I have just to make sure our audience is able to get involved. Both of you have noted at several points in the talk so far that there are provisions in the Emergencies Act that refer directly to different actions which it permits. And in preparation for today's panel, I read most of the Emergencies Act and noted that there are it does refer to some acts and actions which have already been undertaken by the federal government, such as emergency payments and the distribution of essential goods. while other authorities that are assumed to the federal governments within the Act have actually been undertaken by provincial governments, such as the establishment of emergency hospitals and the restriction of travel. What does this say about federal power in Canada, and what kind of precedents does it set, if any, for a future use of the Emergencies Act? Chrisma, would you like to start?
Sure. So I think what it shows is that, in fact, the federal government has very extensive powers already under a variety of authority, jurisdiction, and that it has been able to use those without having to invoke the Emergencies Act, which I would note, as Kathy has pointed out, itself comes within a highly regulated and controlled framework. So, for example, there's a time limit on responses to public welfare emergencies that would then have to be renewed, and that doesn't leave the federal government as much flexibility. So, in terms of precedents that are set, I'm not sure. Like, I think we are, first of all, we're still within the scope of the emergency, so we will be in a better position to assess, I think, once we're on the other side, whenever that is. But I think that, at least from the federal side, what we've seen is that there is already significant authority that exists completely independently of the Emergencies Act. I mean, we haven't even talked about the criminal law power, which is plenary, which allows Parliament to do pretty much anything if it has a criminal public law purpose in mind and it attaches some sort of penalty to it, right? Like that could encompass a whole host of things. Arguably, you don't even need the Quarantine Act. It's good that we have that framework, but the criminal law is expansive. So, that would be some of my thoughts on that question.
And I would just add to that, what we're seeing coming out of this situation is that the bar has been set very high for the use of the Federal Emergencies Act. That's critical. That's going to be a precedent for the future. And we're going to know that the federal governments are going to be a little more hesitant. It's also set the precedent that we have to maintain the balance between local control and national powers. So we want provinces to have local control over local affairs and the federal government to stay at the national level, which is why one of the criteria for emergencies is something that really does have a clear national dimension to it. But there's also been a really interesting thing, and that is the federal government, whenever it wants to have its way with the provinces, uses its spending power, and that's what it's done during COVID-19. It has relied on its spending power to be its most effective way of influencing the provinces and ensuring that things do get done. And that extends right into provincial jurisdiction, but in a way that the provinces can accept because it comes with dollars. So.
And actually, Mark, if I could just add one other point that just is a bit separate from what Kathy's just said, is another precedent that we are currently experiencing is just the realization of how extensive the provincial powers are. And it's really been at the provincial level that we've seen some unprecedented actions taken. I'm thinking particularly of border controls interprovincially, which are something very, very new, in some ways very concerning. And we've seen the federal government being quite reticent to intervene. So what we have, I think we've seen that a lot of the balance of power when you're dealing with a public health emergency, it rests with the provinces.
Could we take a quick second to, you mentioned or hinted at some of the actions that the federal government might take if it were put into a position where it invoked the Emergencies Act. Could you share a bit more detail with us about what that would look like and how it would be different from the status quo? Maybe Kathy, you'd like to start us?
If it were going to invoke the Emergencies Act?
How would its powers look different, and what would it do differently than in the present? How would it affect the federal government differently?
I think more it would, well, the federal government could act, and it could have sent the military into the seniors' homes on its own authority under this act. Again, though that assumes that there is provincial incapacity, but that's where the case could be made that provinces were obviously not dealing with this and the federal government had to move in. To do that would be politically tougher than legally tougher, because the courts are going to defer to the federal government on this. And in this instance, the federal government would be taking on Quebec pretty strongly, and Ontario. And that would cause a real backlash. But one of the big things that I think that we would see is being handled differently is the role of Parliament. You know, during COVID, Parliament was just sidelined. It did not have much of a role to play. It looked like it was irrelevant. It looked like it was weak. The opposition parties didn't play a role. And so I think if the federal government invoked the emergencies legislation, the role of Parliament would increase, the scrutiny of what government's doing would increase, the scrutiny of its spending would increase. And so I think there would actually be a bit more democratic accountability coming out of this. That is fairly important.
Yeah, I would say possibly it could ensure some more consistency in the messaging around behavior and around expectations for things like social distancing. I say that with the caveat that that may not be the best public policy response in a nation as diverse as Canada is. And I do have a healthy respect for the principle of subsidiarity and the idea that local authorities are often the best place to make that call. But when you have an event that certainly, you know, at the biological level, it poses the same threat, there was a lot of debate and critique over the different responses because people in one jurisdiction notice what's happening in another jurisdiction, and they use that perhaps to gauge whether their behavior is truly risky or is subject to appropriate limitations. So there might have been a role, you could see the idea that the federal government could have taken charge. I'm not saying I necessarily buy that argument in full, but it is one that's been made, and you know, you can see the force of it.
Now, as many of you know, my key interest is in technology policy, so I'd like to slip a question in there before we start to get to our final questions and questions from you, the audience. We've heard more and more about the use of contact tracing apps, data mining, and emerging technologies of other kinds as important, albeit controversial, tools in the fight against COVID-19. What commentary does current emergency legislation make on these technologies, if any? And either directly or indirectly through proxy issues for things like privacy protection?
Sure, I'll start with this one. It doesn't appear to me that the current Emergencies Act really gives that kind of facility with respect to a public welfare emergency. There are references to controls over utilities and property that's a bit broader in some of the other categories. So I'm not sure that the Emergencies Act would be the framework for that to occur. I think there are existing federal powers that could be utilized. The Emergencies Act does make a reference to our continuing obligations under the Charter, which, as I've said, are not suspended, right? Continue to apply, and that's probably going to be the framework and the analytical construct through which we analyze this kind of choice. And of course, we're seeing a really fierce debate about the role that technology can play in our response to pandemic. So we have this 21st, you know, hyper modern response that's being discussed at the same time as we're using these ancient models of disease control, namely, you know, quarantine and isolation. So I think one of the things that's informing the debate is that we already have a pretty well-established set of views, biases, perceptions about technology and its impact on society, about the companies and platforms that will likely be called upon to provide some assistance. And I think we should just be aware of those pre-existing biases, both negative and positive. So a few things that would come into play here that would be very important in any legal analysis: whether the technology is being imposed on people or is being offered, so the question of mandatory versus voluntary use, how the particular information is being collected, is being aggregated or disaggregated, how it's being stored. These are really important concerns. What use is made of it, and importantly, might it be available to law enforcement, right, for a completely unrelated purpose, or is it going to be really cabined off? How effective is the data collection tool? Now, I want to point out that in any judicial treatment, the courts are unlikely to get really into the nitty-gritty of whether the tool is effective or not, but they will look for evidence that there was at least a reasonable perception that it could assist in some way. So some technical arguments will be called upon there. And then I think also, would using the technology, which raises privacy concerns, perhaps mitigate other rights infringements? So we can't forget that the lockdown is one of the most profound infringements on our civil liberties, on our actual mobility. And so to the extent that we could lessen those restrictions, maintain a more open social control, or maintain more open social behaviors through the use of what may raise some privacy concerns, that would be a balance that the courts would look at. And then very clearly, is it time limited? Is it crafted to respond to the particular situation? And is it subject to independent oversight?
And I would just add to that it's going to be interesting, because we have a couple of conflicting demands in an emergency like this, which is not unusual. And one of them would be, we want really good data collection. And that does raise some privacy questions, particularly when we get into wanting data broken down according to race, class, place. So those things are going to impose challenges. We have charter rights coming into play, Bill of Rights. We have international declarations that do set some limits, but they're still vague. The Canadian Securities Intelligence Services Act would probably come into play a bit more here, and some of the cases that have dealt with privacy rights in the past. But it's going to be a tough call, and there are going to be some really conflicting demands made of government to collect the data we need to deal with pandemics of this sort in the future, or if it's, say, a public order emergency in the future where this legislation is used, same thing comes up, and this interferes in people's lives. So that's a tough question, and it's going to be a fascinating one to see it evolve.
Final question from me before turning it over to our audience. If you do have questions, put them into the chat and we'll get to as many as we can. The final question for me is, what advice would you give a senior public servant or executive today who is perhaps not directly implicated in the public health portfolio, but is nonetheless operating under the current emergency conditions and wants to know how they can maybe do their job better or more effectively?
I can start on that. The first thing I would say is, we have seen a public service that moved quickly with alacrity to deal with the challenges before it. It overcame the natural tendency towards risk aversion. So one of the first things I would say is, get your team together and start to talk about, how do we create the right balance going forward in the future? Because some things will be wrong and there'll be a retrenching back to a risk-averse position, but they can deal with that. Secondly, we've seen the provinces, municipalities, and Indigenous governments can work effectively and quickly. So have some respect for working with them in partnership, because a lot of good ideas will come that way. And the last thing I would say is watch and learn from the public. But I would also encourage you, and I'm speaking to the converted here, and that is get involved in organizations like IPAC and CAPA, because one of the critical things is the Canadian Public Service responds really well. And I'll give you one short anecdote by comparison. When I was speaking at the National Seminar on Teaching Public Administration Online, that day I opened the paper, and the President of the United States had ordered the police in to deal with this street demonstration. In contrast, I looked at another column, and there was Canada. And there was our Chief Public Health Officer saying, well, it's better if you don't demonstrate, if you stay home, because that would be more reasonable and safer. But if you do have to demonstrate, don't yell, because that ejects too many germs, possibility of contamination. She said, or if you have to yell, please wear a mask. And to me, that encapsulated the difference between Canada and the United States. And it told me that organizations like IPAC and the schools of public policy and public admin across the country are doing the right job in training our servants to be the type of people we want. So rely on that.
I think if we were in person, you'd get a round of applause right about now. So, Chrisma, anything you'd like to add?
You know, I don't have a lot of expertise in public administration. I have tremendous admiration for civil servants. I think they have done yeoman's work and just have been under extremely difficult circumstances. I guess what I would say as much as possible is try to ignore all the noise. You know, we are experiencing this pandemic in quite an extraordinary public discourse atmosphere, and that can make it very difficult to sort of separate wheat from chaff. And I'm sure that there are a number of younger people here, but I would also say moderate your use of social media, because I actually think it can be highly, and I am on social media, don't get me wrong, but I actually think it can be very insidious, and can often give you a distorted picture of how public issues are actually being thought of and debated.
Great. We have time for one question, and it comes from Lily Speck. The question is, from your vantage point, has the recent use or lack of use of emergency legislation been a success story for Canadian federalism? What could have been done differently? What could have been done better?
Well, I'll take on the first part of that. And I think the federal restraint has been appropriate. I certainly think that their framing of the Emergencies Act as a last resort is correct, both legally and as a matter of Canadian federalism. You know, in hindsight, are there things the government could have, should have done differently or more quickly? Undoubtedly, yes. But I think that the clear attempt at cooperation with the provinces, the attempt among first ministers to really coordinate was the right move in a federation as complex as ours. And while some have criticized the federal government for some temerity in its response, I think in hindsight, it probably was the prudent move to really rely on the strengths that the federal system sort of gives to the various orders of government and try and facilitate the response as opposed to Bigfoot it and take it over.
I would agree with that. The federal government has acted appropriately in not invoking the emergency legislation. However, I think one of the things that has really been a low standard in our response to this crisis has been democratic accountability. We have not had Parliament scrutinizing the acts of the executive. And when we have Parliament in operation, when we have the opposition parties, and they're now more diverse, asking tough questions of the government, when the Senate engages the government on these questions as well, we get better legislation, and we get a government that thinks things through from a different perspective and understands things in the way that Canadians really need them. So although they were correct with respect to the provinces and not invoking the emergency legislation, I think it's regrettable that Parliament was sidelined by the agreement that was signed by a number of the parties. By the agreements, I should put that in plural. I'm very encouraged by the fact that they're looking at developing an app for voting, because in future that will mean that they can have a hybrid of Parliament where there is voting, and that would be much more similar to what the British have done so successfully. And it would really bolster our system if they actually did that.
Well, allow me to thank you both for participating with your candor and alacrity and wealth of knowledge. I'm going to now pass the microphone to Taryn Wasson, who is the president of the IPAC National Capital Region chapter and our fearless leader for our outro. Taryn? I may have to unmute Taryn. Taryn may be unavailable right now. Thank you very much for coming. Carissima, Kathy, you've been excellent. It's been really, really awesome to follow you in this conversation, some of which was peppered with my own personal interests as well as some for the audience itself. And thank you as well to the audience. We're very happy to have you joining us tonight, and we hope to see you again soon at other fabulous IPAC events that we'll be having in the near future. Thank you. Have a good evening. See you again soon.
Thanks
Thank you, Mark. It's been a pleasure. And hi, Lily.
Bye, everybody.